Hi, everyone, and welcome to the discussion, our webinar on the American Legion versus American Humanist Association case, recently decided yesterday by the Supreme Court. This is a really significant decision, which we believe will undermine the separation of religion and government in our nation. We'll be discussing this between three different presenters. I am Allison Gill, the Vice President for Legal and Policy with American Atheists. The first presenter will be Jeff Blackwell, the American Atheist Litigation Counsel. And then Nick Little will be presenting, and he is the Vice President and General Counsel for the Center for Inquiry. And with that, I will turn it over to Jeff to get started to talk a little bit about the history of the case and the background in this type of litigation.
Thanks, Allison. It seemed like it was appropriate to start today's conversation with a discussion of sort of how we came to this place, and rather than starting, all the way back at Marbury versus Madison or something, I'm going to start in 1971 when the Supreme Court issued a decision called Lemon v. Kurzban. That decision laid out a three-pronged test for determining whether or not a government action violates the Establishment Clause. A government action, if it's going to pass constitutional muster, has to meet all three prongs of the Lemon test, and those are that the act has to have a secular purpose. It cannot have the primary effect of either advancing or inhibiting religion, and it must avoid creating an excessive entanglement between government and religion. Now, those three prongs all have a lot of wiggle room. For instance, the third prong presumes that some entanglement between government and religion would be permissible, but only excessive entanglement is forbidden and does not really clearly lay out what constitutes excessive entanglement. Also, a secular purpose can be one among, well, there can be multiple purposes, and as long as the government has a secular purpose among those, that will be accepted by the court. Only when purely religious purposes are shown would something violate the secular purpose prong. There's also wiggle room between deciding what is the primary effect of an act. If something incidentally advances or inhibits religion, that's not a violation of the Establishment Clause under the second prong. And my apologies for coming at those out of order. So the Lemon test was what the court laid out in 1971, and it was a summary of tests that had been used by the Supreme Court and other courts in the past. It was relied on to a greater or lesser degree by the court for about 15 years until 1984, in a case called Lynch v. Donnelly, where Justice O'Connor laid out in a concurring opinion her sort of gloss or interpretation of the Lemon test, and she combined the secular purpose and primary effect prongs of the Lemon test into one inquiry that was whether or not the government was endorsing a religious perspective. Basically, those two prongs of the Lemon test, whether it has a secular purpose and whether it has a primary effect of advancing or inhibiting religion, are two methods of going about determining the same thing. And she also added another aspect to that inquiry, which is, would a reasonable observer think that the government was endorsing a religious perspective? So by 1984, the court had fairly reliably applied the Lemon test. They muddled it a bit after 1984, and things became progressively more complicated and patchwork as we progressed through the 1990s into the 2000s. Then, in 2005, the court issued two opinions on the same day, both involving Ten Commandments monuments on public property. One was Van Orden v. Perry, and the other was McCreary County v. ACLU of Kentucky. Those two decisions came out in completely different ways. In Van Orden v. Perry, a Ten Commandments monument standing on the Texas state capitol grounds was permitted to stay. In McCreary County, a Ten Commandments display in a county courthouse was determined to be a violation. The only person of the justices who voted in the majority in Van Orden v. Perry, which allowed the Ten Commandments monument to stay, Breyer was the only one who sort of shifted the balance between allowing the monument and not allowing the monument. And in his concurring opinion in that case, he lays out a fairly amorphous standard that kind of guided his reasoning. Allison, you have a fun guest. He basically said in his concurrence in Van Orden v. Perry that longstanding and previously unchallenged religious displays, or the fact that a display was previously unchallenged before someone brought a lawsuit, suggests that the community has considered the religious aspect of the display's message as part of what is a broader moral and historical message reflected of a cultural heritage. And that's, I did a little bit of paraphrasing there, but that's essentially a direct quote from his decision. He decided that in the case of the Ten Commandments monument on the Texas state capitol grounds, the monument itself did not send a message of religious endorsement of a religious position by the state, because there were a bunch of other displays on the grounds, and this Ten Commandments monument was comparable in size to the other monuments on the grounds. And since it was not, since it was sort of part and parcel of what the other monuments were saying, they were, according to the court, delivering the message that these are all things that are important to Texas history and heritage. And according to the court, because it was not given greater prominence than the other monuments, it did not change that message, which was a secular one. So that was the difference in Van Orden v. Perry versus McCreary County, and much scholarly work has gone into studying the and breaking down, splitting hairs between those two cases, both of which come up a lot in religious display cases. In our work and to a certain extent, I assume, in Nick Little's work over at CFI, we deal with cases of governments erecting religious displays. They come in various forms. Obviously, Van Orden v. Perry and McCreary County dealt with Ten Commandments monuments. But every year we deal with the war on Christmas and nativity displays that are put up by local and state governments all around the country. Lynch v. Donnelly, in which Justice O'Connor articulated her endorsement test, was one such case. And then there are cross cases, which is what the Bladensburg cross dealt with. Some significant ones over the past decade or so, when it comes to crosses, were Salazar v. Buono, in which the Supreme Court addressed the question of whether Congress could prohibit federal funds from being used to remove a cross from federal land that had already been declared unconstitutional. Interestingly, that was a war memorial erected in the Mojave Desert in 1941. The lower courts said it was unconstitutional, and that question, whether or not the cross itself on public land was unconstitutional, was not before the court, the Supreme Court. So the Supreme Court didn't address that question. Interestingly, also in that case, then Solicitor General Elena Kagan presented the government's argument for why Congress should be permitted to prohibit federal funding from being used to remove the cross. Less than a year later, she was appointed and confirmed to the Supreme Court and wrote a concurrence that we'll get into in this case later. There's also Utah Highway Patrol Association, the American Atheists. This was a case that we brought in which challenging Utah's practice of erecting crosses with the state seal on them along highway roadsides to memorialize fallen law enforcement officers. The 10th Circuit Court of Appeals sided with us in that case, and the Supreme Court declined to hear it. So the 10th Circuit's decision stood, and Utah cannot put up those crosses. That was a practice that the state started in 1998. And we'll get into the reason, the year that these practices began and when crosses get put up and displays get put up later on in the presentation. Lastly, there's a case currently before the court called Kondratev, and I probably screwed up that pronunciation, v. City of Pensacola. The city lost at the appellate level and has requested that the Supreme Court take the case. The court has yet to decide whether or not they will take that case, in which a cross was erected in Pensacola's Bayview Park in 1941. So that brings us to the current case, or the case that was just decided. This concerned the Bladensburg, Maryland Peace Cross, which was erected in 1925 as a memorial to World War I veterans. The AHA challenged the cross in 2014, and won at lost at the trial level in 2015, appealed to the Fourth Circuit Court of Appeals, and won at the appellate level. The appeals court overturned what the district court had said, and as a result, the American Legion and the Maryland National Capital Park and Planning Commission appealed the loss at the Fourth Circuit level to the Supreme Court, and we've just gotten the decision from the Supreme Court, which Allison is going to fill you in on.
Great, thank you so much, Jeff. So overall, I'll be talking about the decision itself. This is a fairly complex decision with a few different subparts, so I'll start with the basics. The court found 7-2 that the Bladensburg Cross did not offend the Establishment Clause, and therefore that it is constitutional. The court's opinion was written by Justice Alito and joined by 4 other justices for the most part. There were 2 sections where only 3 other justices joined Alito's opinion, which forms a plurality of 4 justices. So that's not the opinion of the court, but it is 4 justices. And there are 2 other justices that joined in the judgment, but with their own reasoning. And there was also 2 justices that dissented. So I will focus on the court's opinion and the plurality for this discussion. So the court began by discussing the history of crosses broadly, and also within the context of memorialization of those killed in war. It makes the case that although the cross is traditionally a religious symbol, the cross takes on a secular purpose in these contexts, and gave some reasoning as to why. The court then looked at the history of this particular cross and summarized the various different holdings below, which analyzed the case through the lens of the Lemon test and reached conflicting results. As Jeff said, the district court and the circuit court reached conflicting results using basically a Lemon analysis. The second section is probably the most significant of the opinion, and it has 4 parts, A through D, 2 of which were supported by the court and 2 were supported by the plurality. So part A, which is a part of the plurality decisions, is supported by 4 justices, is a focused criticism of the Lemon test and its supposed failings. The court said that the test does not align with SCOTUS, the Supreme Court precedent, nor with constitutional practice. The plurality advises for this category of cases, that is, displays, symbols, and practices with words or symbols that are religiously associated. The Lemon test is not a suitable test, and there should be a new presumptive constitutionality test. So the court is basically saying the Lemon test in this particular type of cases, the plurality is saying in this particular type of cases, the Lemon test should not apply. There should be a separate test. Notably, these types of tests are distinguished from various other types of Establishment Clause tests. So the court, even the plurality here, is not saying this applies more broadly. They're saying it just applies in this context with these particular types of cases. That is the symbols, monuments, displays, and practices. Then part B, which is the court's opinion, so it's no longer the plurality. This is controlling law. The court laid out a four-part criticism of the Lemon test in this context, which is long-standing displays, symbols, and practices. The first two items on this list go to the intent prong of the Lemon test. So they sort of align. In many ways, this analysis sort of aligns with Lemon and the various different prongs of it, and why it's basically a criticism of Lemon, if that makes sense. So the first two parts really go to the intent prong of Lemon. First, it says if a monument was established long ago, it might be difficult to identify its purpose. Basically, the court is saying that there's no way for the court to be certain about its intentions, and that it would be inappropriate for a court to remove the monument based on this uncertainty. And I have to say, it's odd to hear an originalist speaking this way about long ago intent, when their entire judicial doctrine is based on divining the intent of the founders of the country and long ago lawmakers. But in this context, it is not possible, apparently, to figure out the intent of the creators. Second, there might be multiple different purposes, only some of which are religious, and the monument may acquire additional purposes over time. Third, so this is the third item in the four-part analysis. Basically, this goes to the Lemon effect or endorsement type test. And the court is saying that the message conveyed, even if it started out as a religious message, might change over time. So the context might change over time. For example, explicitly religious symbols may take on community or historical significance, and therefore that might then be the effect of the message that is conveyed by the symbol. And fourth, when a symbol or display with historical significance is removed, says the court, it may convey a hostility towards religion that is not neutral. And I have to say, I find this part of it, this decision, to be the most dangerous. So there's some superfluous language there about removing these monuments to militant secularism and regimes that go around destroying monuments as an attack on religion. But basically, it's saying that to take down these monuments somehow is historic. It might represent hostility towards religion. So together, these factors result in the court establishing a new, or putting forth a new test in place in the Lemon test in this context. And as a reminder, the context is long-standing, religiously expressive monuments, symbols, and practices. So in this circumstance, the court says that for long-standing religiously expressive monuments, symbols, and practices, and only this category, there is a presumption of constitutionality. Now, a presumption of constitutionality, typically when there's a presumption, it is rebuttable. The court did not talk about how such a presumption could be rebutted in this circumstance, nor did it define what long-standing means. Jeff spoke about this cross being in place for 90, 95 years. But what if it was in place for 10 or 15 or 20 years? It's hard to say. And the previous cases that have been in this area sort of all over the map in this way. So it's unclear what long-standing means, which is another sort of failing here. And it's also likely that the four factors I just spoke about that the court went into, it's quite possible for them to be applied to other contexts, even if they don't fall in this sort of framework that the court is establishing for long-standing display cases or monuments. These factors could be talked about in different contexts as well. And Nick will talk more about that, what that means for the state of the law. So in part C, which is also the opinion of the court, they applied this sort of reasoning and test to the Bladensburg cross. And the court said that it is impossible to know the intent here due to age. And it really makes it clear that even if there was religious intent, the commission, say that they want to preserve it for historical and traffic safety reasons. And that's sufficient to the court. They don't really do a very searching analysis there about what the actual intent is. If they put forth this sort of, well, it's better for traffic, that sort of analysis is sufficient. So they were willing to take this argument and not much look into it. So there's not really much focus placed on intent at all by the court here. It really doesn't show much importance to the idea of intent, especially because that intent, as the court says, can change over time. There's also not much analysis regarding the effect or endorsement the message conveyed. The court implies that it is enough that there are other monuments around and that this is an intersection. I don't know what this is an intersection means or was intended to mean, but there's almost no analysis here. But there's certainly not a searching analysis. It's just sort of taken at face value that there are other monuments around and this is an intersection. Therefore, there's no message conveyed. There's no endorsement of Christianity. So it's very hard to understand exactly what that test means if it applies at all. And lastly, the court said that the removal of this monument would be seen by many as not a neutral, but a religiously hostile act. Oddly, the court indicates that even if the religious association is not at the forefront, like they've said, the message has changed over time, the context has changed over time, it's not explicitly religious, it has historical value. So, okay. But somehow that's true, and also true at the same time, taking it down would be religiously hostile. So it's not religious for purpose of keeping it up, but it is religious for purpose of taking it down. It's not very logically consistent. So there's a lot of internal conflict there. So this section is the most concerning to me because the ideas could certainly be applied in other contexts. Part D, which is also just the plurality, it's not the majority. This section is a bit muddled, in my opinion. The plurality gives favorable attention to both the idea that the Establishment Clause must be applied with reference to historical practice and understanding, and also that practices favoring inclusivity and non-discrimination are favored. And Nick will go into that a little bit more in the context of Justice Kagan's concurrence. But it's sort of a little bit of a back and forth there. It's not really clear what the court is trying to say in Section D. And then there are a couple other concurrences and dissents. I will just speak briefly about the concurrence by Justice Gorsuch, which Thomas also joined, which would have denied this case standing, which means basically that the petitioners, the American Humanist Association, would not have the ability to go to court in the first place to challenge this cross, because basically it's called an offended observer standing. They basically would not have the ability to enter the court in the first place because they would not be able to. And this way makes it very challenging to enforce the Establishment Clause and make sure it's upheld by the courts. Because if you can't go to courts to complain about these religious symbols on public land without having some direct harm to yourself, it makes it basically very, very challenging to protect the Establishment Clause. And so this is really problematic. Now, this concurrence says that it lays out some situations where there is religious coercion, and it talks about how those would still be able to be the basis to go to court. However, those are really all free exercise claims. They're not really Establishment Clause claims. So if that is true, it really means the Establishment Clause has no force. People just have the right to go to court to protect their free exercise rights. So that's the concurrence. Now, Justices Gorsuch and Thomas joined the majority, concurred with the majority opinion, but did not join the majority. So that's why it's a 7-2 decision. And lastly, I'll just mention the dissent. Justice Ginsburg, joined by Justice Sotomayor, brings some sense to the discussion by saying the cross is obviously and inherently a religious and inherently Christian symbol, which has been the court's reasoning on this issue in the past. She says that when a cross is displayed on governmental property, the government may be presumed to endorse its religious content. So that's sort of the analysis she would provide. There's a lot of history about the cross and why it actually is sort of an outlier for this type of situation. It is, it was not typical for war memorials at the time even, and also why it's a religious symbol. But again, that was only 2 justices that signed on to that position. And so that was a basic analysis of the case. With that, I will turn it over to Nick to talk about some of the other concurrences and also the implications for this case.
Hello, and thank you to American Atheists for having me on this. It's hard to say with any degree of certainty what the implications of this case are. This case came down yesterday. We're still analyzing it, and we haven't seen how it's going to be used in the future. But if I was to do some tea leaf reading, it's not good. It's not good how it's going to be used. An old law school professor of mine used to tell me that the Supreme Court generally gets things right, except for in 2 areas. And those areas are sex and religion. And when cases are about sex or religion, they have some really bizarre opinions. And if we look at cases like the Masterpiece Cake Shop case, which involved both sex and religion, and the Hobby Lobby case with sex and religion, you get completely weird opinions. So there we are. One way of looking at this case that it's not going to have a lot of effect. And that way is based on this idea that they really didn't do much in here. There's no sweeping new rule. On its surface, this opinion applies only to 1 cross in Maryland. If it applies to crosses that are war memorials generally, it applies to a very limited number of situations across the country. And Justice Ginsburg made that very clear in her dissent when she was saying it's like, listen, people at the time knew there was a problem with sticking up a cross to memorialize everyone, so they just didn't do it. But that's in my view, an incorrect way of looking at this case. Not Ginsburg's view, the idea that it's not going to have a wide effect. Trinity Lutheran was a very narrow case. It allowed state funding just for a very specific resurfacing of a children's playground. But it's now being used to have a very wide impact. So I'm going to talk about that. But before I do that, I just want to say what this case didn't do. This case didn't kill the Lemon test, although the Lemon test is pretty obviously on life support. And it's been on life support for a while. There are at least 6 justices who, through their opinions in this, indicate either that the Lemon test should not have been used in this case, or that the Lemon test should never be used at all. They just didn't all sign on to saying that. In its place, it is very likely we in the near future will get a coercion test, which will be based around the idea that if you are not physically forced by the government to take part in a religious activity, you have not been harmed under the Establishment Clause. And there's been a lot of emphasis placed on Justice Thomas's concurrence, where he talks about the Establishment Clause not relating to the states. This is ridiculous. It has no legal basis whatsoever, but it is Thomas being Thomas. He's done this in every Establishment Clause case that I remember in recent history. So I don't think we have a vast amount to worry on that. I mean, if we do, we're in just incredible amounts of trouble. So what did this case do, and why is this case dangerous? Dangerous in a key respect because it relies, and Justice Alito relies on a very new notion, and that's the notion that the religious can become secular if enough time expires in between. There's a major problem with that, and the problem with that is the changing demographics of the United States. If we look at when the United States was founded, if we look at the colonial times, it was, well, amongst people who could vote, it was overwhelmingly a Christian population. The Native Americans, of course, weren't Christian in large part, but they didn't count for the makers of the Constitution. There was a lot of absence of Christianity amongst imported slaves, but again, they didn't count for the makers of the Constitution, except to the extent that their slavery was to be continued. So we looked at a country that was overwhelmingly made up of Christians, but that has changed. So anything that has the history to pass under this test is inevitably going to come from a Christian background, because there were not large numbers of Muslims, large numbers of Jewish people putting up memorials with state funding at the time. Same with the non-religious. So basically what it's saying to me is that because Christianity used to be a dominant religion in this country, it should go on being given special treatment. So that's one key takeaway from it. There's also another key takeaway, which goes to, I have repeatedly critiqued Justice Alito, not just because I disagree with his views, but I don't think he's actually qualified, in particular in the intellect side, to serve on the court. And yet again, he's come out with what will be a very broad-reaching opinion without any detailed analysis either of the reasons for it or the consequences of that. We have a 40-foot concrete Latin cross on the busiest traffic intersection in the state, pretty much. And we are told that that is secular. If a 40-foot concrete cross on state property and maintained at taxpayer expense is secular, there is literally no boundary to what can be considered secular in this. 50-foot cross is not fundamentally different to a 40-foot cross. The cross is, without a doubt, the fundamental and basic symbol of Christianity. And this is not a cross such as you see on the Swiss flag, for example. This is clearly a religious cross. So if a 40-foot Latin cross is secular, there's no boundary on what could be secular. But what I find most interesting in this case is, because, as Alison mentioned, there are so many different parts, is what does this tell us about the views of the 9 justices on the Establishment Clause and on religion in general? First thing it tells us is those of us who believe in a robust defense of the Establishment Clause, we have 2 justices out of 9 on our side. We have Justice Ruth Bader Ginsburg and Justice Sotomayor. And unfortunately, we know Justice Ruth Bader Ginsburg is not going to be on the court forever. So those are our allies at the moment on the court. But let's look at Alito's opinion. As Alison mentioned, it focuses in on this notion of hostility towards religion, and that's actually kind of insulting in many ways. It turned around and accused the AHA of essentially being like the Taliban in looking to, blow up and destroy these statues of Buddha and having no sense of history and this. And if you look at it, the AHA, although the court deliberately focused on the destruction or the maiming of this memorial, the AHA would have been perfectly okay with selling the land that it is located on to a private organization, and the cross would still have stood there. Alito also, and this offends me as a lawyer and it offends me as a historian, completely misapplies history through his opinion. And he builds up this notion of the United States being a Christian nation. And I don't know if he's watching, Andrew Seidel from the FFRF has very recently published a book on this, which I recommend to all of you to buy, a book called Founding Myth, which is an indication of how this simply isn't the case. And when we look at the history of his opinion, and I don't know how many people have read this, there are some just nonsense statements in there. He spends a lot of time talking about how the cross can be secular and talks about the Red Cross as an organization showing its secularity. He, of course, then chooses not to mention the fact that as a result of the religious nature of the cross, the Red Crescent is the organization that operates in Islamic countries, and does so because the safety and neutrality of the Red Cross couldn't be guaranteed in those countries because of the religiosity of this statement. So Alito's view that changing long-standing practice is religious hostility. We can see this in the Masterpiece Cake Shop case as well, where a single historical comment by one of the officials reviewing the case that Christians have a history of opposing LGBTQ rights, which is absolutely categorically factual, was considered to be hostility towards religion. It is not the case that changing a long-standing practice is hostility. It's been around 60 years since this monument was given to the states. In 1896, in the case of Plessy versus Ferguson, the Supreme Court determined that segregation was legal. 58 years later, in 1954, in Brown versus Board of Education, they determined that segregation was not legal. That was not based out of hostility. That was based out of a recognition that the Plessy decision was simply wrong and failed to apply the 14th Amendment. So that's when we look at Alito's opinion. Justice Breyer's concurrence is what Justice Breyer does on religion cases. He always writes a concurrence saying, there is no one test that applies to everything, so I'm not going to do my job, and I'm not going to try and even give you a test. Not going to spend any more time on Breyer because I'm angry at him. Justice Kagan's concurrence. This is what I see as potentially the most damaging part of this case. Justice Kagan didn't agree with getting rid of Lemon as a test, but turned around and wrote an opinion that says, in particular, here as elsewhere, the opinion shows sensitivity to and respect for this nation's pluralism and the values of neutrality and inclusion that the First Amendment counts. So Justice Kagan is turning around and saying that having a state-owned 40-foot cross on state land maintained at state expense is pluralistic. And that's a very dangerous viewpoint. They've redefined pluralism and neutrality to be whatever the majority wants it to be, as opposed to the recognition that it means government cannot support one religion over another religion, and also cannot support religion over non-religion. So if this is Kagan's view of the First Amendment, and in particular of the Establishment Clause, we are in for a very long, very tough time with these kind of cases. As I mentioned, Justice Thomas's concurrence is just Thomas being Thomas. Justice Gorsuch's concurrence, which seeks to deny onlooker standing, is very troubling. As Alison said, who's going to bring these cases? He includes a line in it that says, only a public school student compelled to recite a prayer will still have standing to sue. So if a teacher is the one praying a Christian prayer in a classroom and simply requires and wants to do it, there's nobody who will be able to sue for that as a violation of the Constitution, and that's dangerous. Justice Kavanaugh, who, as we all know, should not be on the bench. Justice Kavanaugh's concurrence, again, very dangerous. He turns around and says the state isn't actually required to keep up this memorial. They can vote and not pay money for it, which totally goes against the principle of the Constitution and the First Amendment, because it puts which religious monuments are going to be decided into the hands of a majority vote. We may well get a vote to support a cross. How likely do you think it is we'll get a cross support through a vote, a majority vote, to support a crescent, an Islamic crescent, or an atheist A? It's the most non-constitutional thing I've heard in a long time, and that's saying something. So to wrap everything up, to give you an overall opinion, the Lemon test is sitting there waiting to be finished off, but it's still in the hospital bed, and that machine beside it is still beeping. Unfortunately, the Supreme Court has made very clear it doesn't support euthanasia, and so maybe we'll have Lemon for a little bit longer, but the question of when it'll be applied is there. The court will move towards coercion test, and they have made that very clear. And the overall thing I have is, what does this opinion show us? To me, it shows us that certain strategies and certain cases which appeared very broad-minded, kind of this idea, the everyone welcome cases. So we look at the town of Greece case that said, you can have prayer before a town meeting, as long as everyone has the right to give a prayer. Or the Ten Commandments cases that were like, well, the Ten Commandments is broader than just individual sectarianism. It's part of Judaism, it's part of Islam as well, and also it's part of our legal history. So all these cases of open it up to everybody have acted as a Trojan horse, because they've turned around and they have been used to justify what this case is, which is plain and simple, the special treatment given to Christianity. And it's important to remember that this case allows a 40-foot Christian cross on public land maintained by public money. To turn around and say that that isn't an incredible reversal of the First Amendment, an incredible reversal of the Establishment Clause, and a reversal for our entire movement is, in my mind, misrepresenting what this case, the impact of this case will be.
Thank you so much, Nick. So we're definitely able to take questions. If people want to put any questions into the chat, they will be put into our chat and we'll be able to see them as well. So please feel free to do that if you have questions for us. In the meantime, though, we have some discussion items I wanted to bring up. Nick, we've talked a little bit about the hostility aspect of this, and there was some discussion of this by Kavanaugh. However, my question is, under this analysis of hostility, is it actually true that states and municipalities can change mottos, take down monuments, or remove different practices with a religious association? Or is that now too hostile? Kavanaugh says it's permissible, but, that he did not, that's not part of the majority's opinion. So it's a little bit hard to say, in my opinion. And I feel like if we can't remove these things, it sort of creates this one-way ratchet where we can add new religious items based on these principles, but we cannot remove them. And at a time when our society is becoming less religious and there's more plurality of religion, our laws in society will only be allowed to become more religious, which is really troubling. But I'm curious about your thoughts on that. Is that something that that we'll see in the courts? I mean, one question is, if it is true, who would be able to sort of challenge the removal of these monuments? So there's a question of standing. But I'm curious what you think.
I mean, clearly, yes. I mean, it's very frightening in that it says, and it shows there's this huge double standard that's going on this when it comes to religion. We saw this with Masterpiece Cake Shop. Any criticism of religion is now being defined as hostility to religion and being defined as you cannot remain neutral. So the entire Overton window, to be very trendy, is shifted when it comes to religion on that. Rather than saying, and we see this in popular culture all the time with the way atheists are treated, if a person says, I believe in God, they are not seen as being hostile to anyone else. If a person turns around and says, there is no God, they are seen as being hostile towards all religious people. And it's an incredible double standard that you've got there. And I had a quick thought that's kind of escaping me on this, and I'll see if I can get to it. This notion that any removal of the past is hostility towards religion just can't be brought up, because it doesn't recognize that the existence of these things in the past is an example of privileging them. So it's not taking them away, is not moving to a situation of hostility. It's moving back to the middle. It's moving back to the idea of neutrality, which all 9 justices, if you ask them, all 9 justices claim to believe in religious neutrality. But taking away a benefit that somebody's been given isn't against them. It's the same with the same-sex marriage cases. You know, allowing gays and lesbians to get married wasn't reducing the rights of straight people. It was increasing. It was returning things to the neutral position, which is where we should have been in all the time.
I want to jump in and address two questions there, or 2 points you had there, Nick, because particularly first with regard to the double standard. We have here AHA coming to the court and saying the government should not be spending money supporting what is a blatantly religious symbol as a monument to all veterans of all wars. They should not be doing that. We should restore neutrality by selling the property, moving the monument, turning it into an obelisk, what have you. That Alito characterizes as hostile, while at the same time, in the same opinion, characterizing the AHA's position as militant secularism, and comparing it to the ideological cults of personality that you had in the USSR and in China, and the French Revolution, where there was an effort to eradicate religion altogether because they didn't, religions didn't conform to the prevailing ideology. And that is not at all what is being asked of the court. And yet, apparently it's not hostile to characterize the position of trying to enforce the Establishment Clause as militant secularism. I don't even, given the definition of secularism, I don't know how you have militant secularism. It's absurd. So I wanted to, that portion of the opinion made me angry. My notes there were, I got all scribbly on my paper at that point. But I wanted to go back to something that Allison mentioned, and this discussion of, would it be permissible for Maryland to decide to remove it, as Kavanaugh intimates? The majority opinion in Part 2C of the opinion, which is the majority, a majority of the justices got behind, he says, few would say that the state of California is attempting to convey a religious message by retaining the names given to many of the state's cities by their original Spanish settlers: San Diego, Los Angeles, Santa Barbara, San Jose, San Francisco, etc. So keeping those does not send a religious message. Okay. He continues, but it would be something else entirely if the state undertook to change all those names. Much the same is true about monuments to soldiers who sacrificed their lives for this country more than a century ago. So the majority opinion is saying, no, that is sending a religious message. If you take down something that is religious, or try and remove a government mention of religion, that is hostility. And I find it incredibly troubling.
I agree. It's pretty worrisome. It's unclear how lower courts will interpret that language. Just while we're talking about this religious hostility part, I guess my next question is, the religious hostility language echoes and builds upon previous recent cases, as Nick was mentioning, including Hobby Lobby, Trinity Lutheran, and especially Masterpiece Cake Shop. What effect, if any, will this case have on the enforcement of non-discrimination laws, which, of course, opposition has been trying to focus on and brand as religiously hostile? If discriminatory practices are long-standing and associated with religion, is it now hostile to religion to remove them? And so that's my open question. So whoever wants to take it.
Yeah, I mean, there's certainly an element of that. I don't think this opinion in itself is going to be used in that manner. But what does it show us about the thinking going on? And to me, it shows us that the thinking is that there are 7 justices who are largely okay with the concept that criticizing religion is hostility towards religion, and are so defensive of the notion of religion that they may well do exactly what you say and say, yeah, requiring a Catholic adoption agency to equally serve the whole community and place children with LGBT parents is requiring them to do that is hostile to their religion. Well, then, on the other hand, is their religion by definition hostile to LGBTQ people? No, because we found out that saying their religion is hostile to LGBTQ people is in itself hostile to religion, according to the Supreme Court. Yeah, I think you're right of the danger of what can happen here.
Well, it's certainly going to be how the opposition uses this case, right? Certainly. We've already seen that being used by the administration in various different ways to justify cutting back non-discrimination rights in regulations. So it's, in this case, just adds fuel to that fire.
It's interesting to think about. Oh, sorry, Allison, continue. It's interesting to think about also the double standard here, where stating facts about what, I'm not going to try and paint with too broad a brush here, but what many Christians use their religion to justify, stating facts about what religion can be used to do, is hostility. But in cases where people are trying to use the free exercise clause to permit them exceptions from laws, the courts will not even question factual assertions that are made by the people claiming they deserve an exemption. We had plaintiffs claiming that certain forms of birth control are medicines that cause abortion, when factually, biologically, that's simply not the case. But because they believe it, the court won't take the actual facts into account. We're living in this weird situation. There's the idea of a legal fiction, and I think the legal fiction is starting to. I think legal fiction is swallowing up everything at this stage. It makes absolutely no sense to me. In our earlier discussion, I called what the court is doing here irrational basis review, because that the state can come and say removing a 40-foot cross from an intersection causes a traffic issue as a legitimate interest for leaving it there, when surely a 40-foot cross in the middle of a traffic intersection is more of a traffic issue, because people will want to look at it while they're driving through a busy intersection. You kind of just don't know what to say when you try and put yourself into a mindset in which that makes sense.
Yeah. I actually have a good question to follow up on that that was entered in the chat. Since the Supreme Court is traditionally a rather static body, what can we do on the local and state level to support secularism? And I think that's a great question. So one thing, American Atheists actually does a lot of advocacy at the state level and local level through our programs, and we have grassroots sort of state directors. You can find all that information on our website, www.atheist.org. One thing we put out last year that we'll be putting out another version of this year is the State of the Secular States, which is a report that looks at about 30 different measures, types of laws and policies that affect the separation of religion and government in every state. And so you can look at what your state has in terms of positive and negative laws and policies and work to change them. I'm getting involved with a local affiliate. There's some in every state. So get involved with local affiliates, and you can work on policy change to address some of these issues at the local level. Because, I mean, that's where we can make the most difference right now, especially given the current administration. So there's a lot that can be done at the local level to reset the balance. And, of course, states all have their own constitutions and their own protections. So they can define how they are protecting the separation of religion and government differently than the federal government does. And so let's work together to make that happen. You can also sign up for alerts on the American Atheist page as far as states, bills, and legislation, and there's a lot going on in that arena as well. Did you have something to add, Jeff?
I was going to say, support candidates for office who support the separation between religion and government. I'm not telling you vote for or against any particular candidate or any particular party, but if an official supports the idea that government should not be getting involved in religion and vice versa, show your support for them. Engage with your government officials who, when they take positive steps to protect the separation between religion and government, and speak out constructively when they take steps that go the other way. And use hashtag atheists engage when you do so.
And it's not just voting in the presidential election or the Senate or the House or your state equivalent. This is down the ticket. There's a reason that we end up dealing with ridiculous school boards that try and teach creationism. And that's because the religious groups vote and we don't on school board elections. If you want to make a change, run for school board. Run for your city council. Do things to make sure at the basic grassroots level of our democracy, people need to recognize that a third of the population are not religious, hold no religious views on that. And until we start getting involved at that level, we're not going to be able to adequately put forward our views at any level.
I have one more point I want to go over here. The opinion points favorably to a new monument with Religious Association for Native American veterans that was built in Washington, D.C. So this was recently built, and the opinion is pointing to it in a favorable way. This is the majority opinion. So given that, what does that mean? Does this suggest that the analysis that I talked about, the 4-point criticism of Lemon, is the court saying or winking at the idea that it should be applied not just to long-standing displays, but also more broadly? Anyone want to take that on?
Yeah, we know that's the way they're going. We know that that's what they want to do, that they want to do new monuments as well. And I think that choice, that was a particularly disingenuous part of the opinion, which it's, given the fact that it's written by Alito, it's really tough to find the most disingenuous part. But it really upset me reading that, because let's look at the importance of this neutral observer concept. A neutral observer, in seeing a memorial that includes a reference to Native American religion, is not going to walk away in the city of DC thinking, oh, wow, Congress and the presidency endorse Native American religion. It's fundamentally different than a 40-foot cross representing what has historically been the majority of the population, and not just the majority of the population, overwhelmingly the majority of power in this country. It's two situations that cannot and shouldn't be compared. And I'm not defending the Native American monument in itself on that. I'm just saying that, to try and apply the same rules to that as a 40-foot cross are disingenuous, is the only polite word I can think of for that.
Yeah, I would add that, by citing favorably a monument to one specific class of veterans, a new monument, and saying that that's permitted, that the next step that Christian nationalists in this country will take is putting up a monument to Christian veterans, and citing to that language and saying the Supreme Court has said this is fine.
You're exactly right, I think, on that. I think that's an important point, especially given the prevalence and the activity of Project Blitz, which is promoting Christian nationalism in the States. This opinion makes it, I think, even more difficult to challenge some of the activities they're up to in the courts, which are already difficult to challenge, such as the mottos. There's a lot of favorable treatment towards mottos in this decision, flags, and other sorts of these displays.
It looks like we have another question.
Oh, okay, great. What is, this is a question from the chat. What is next for the Pensacola Cross case?
That's a question that I asked. We don't know. I from my part, I'm genuinely surprised that the court didn't decide, didn't do what's referred to as GBR, grant, vacate, and remand the Pensacola case in the same breath as deciding the Bladensburg cross case. Basically, it would have made sense to send that back to the 11th Circuit to say, you know, please consider this case in light of Bladensburg, or in light of American Legion v. American Humanist Association. I don't know why they...
Just for context, this is a giant cross in Florida, right?
Yes.
On government land.
And yeah, so hearing GBR used in that way is kind of appropriate because it makes me think of the British crime of GBH, or grievous bodily harm, which is what the justices have committed on the First Amendment and on the Establishment Clause in particular.
Well, we are at time. Thank you both for joining, and thank you all for your questions and for joining today's discussion on the American Humanist Association versus the American Legion versus the American Humanist Association Supreme Court decision. We encourage you to get involved with the American Atheists on our www.atheists.org. And also, Nick, what is CFI's website?
Centerforinquiry.org.
Great. All right. Well, thank you so much.